Questions of much graver and universal interest occupy our minds today.
I'm a graduate of the United States Merchant Marine Academy at Kings Point. I come out of there with a Naval Commission. I'm here to speak to you again. We just had a recent show, spoke about national emergencies or emergencies, state of emergency, that is being declared not only on local, community, state-based basis, but even nationally. Back in October 23rd, 2007, there were fires here in California. A state of emergency was declared, and the Coast Guard, as part of Homeland Security, under the cover, under the umbrella of this quote-unquote state of emergency, was carrying on military trials, military tribunals of civilians, of what it is alleging to be civilian. I know of this because I'm a naval officer. They're doing this to me now and to others. They are using the quote-unquote state of emergency to somehow excuse themselves for carrying on military trials or military tribunals of civilians, which is unconstitutional. And it has been upheld by the Supreme Court as being unconstitutional, and no statute, only an amendment to the Constitution can change the Constitution, the super statutes that form the Constitution itself. There has been no amendments to the Constitution. The Warner Defense Authorization Bill, Military Commissions Act, H.R. 1955, SB 1959, and other legislation, even Article 51, cannot change the Constitution. Only an amendment to the Constitution can change the Constitution. And what has happened is they are using this legislation to unconstitutionally carry on military tribunals, military trials, prosecution of civilians before military trials. And the military, or certain individuals in the military, pulled this on the Hawaiians in the middle of World War II. They also pulled this, even in our own Civil War. And that was one of the reasons why Posse Comitatus was passed. It's an act of Congress, I think it was passed in 1872, because the North was using the military as a police force upon the South, which is, again, of course, unconstitutional. It was also found by the U.S. Supreme Court in Ex parte Milligan, just after the Civil War and after Lincoln had been shot, that the suspension of habeas corpus by Lincoln was unconstitutional, that the use of military commissions or military trials or military tribunals of civilians was also unconstitutional. The case precedents on this, not just Reed versus Covert from 1957, but also Ex parte Milligan, Posse Comitatus, and many other, not only case precedents, but statutes as well. Even the Uniform Code of Military Justice itself, which is Military Law Title 10, which is supposed to, in a constitutional sense, presume even someone in the military, because they are still an American, they cannot protect the Constitution unless the Constitution protects them. They are also presumed innocent. But the Coast Guard, as a branch of military, a special branch of military under the Department of Homeland Security now, is saying that it can carry on, that it is a special branch of military that can take Title 10 and military law out of DOD, Department of Defense, move it into Homeland Security, and prosecute civilians under military trials or military tribunals, and use military assets to prosecute civilians. I want to read, this is the order that I received today. I mentioned this in the other show. The heading on it is the United States of America, U.S. Department of Homeland Security, United States Coast Guard, and those are the agencies or branches of the federal government that are involved. So it's, of course, the United States of America, Homeland Security, and Coast Guard against me. The U.S. Coast Guard is the complainant versus Eric Norman Shine is the respondent. The docket number is CG/SNR 030166. The CG case number is 167-1475. And this is a most recent status notice and order. It was issued by Walter J. Brodzinski, administrative law judge. And I have spoken about who this individual is. He is extremely corrupt. He sat on, along with Kenneth Feinberg as a special master, over many of the 9/11 trust fund family cases for families that were injured by the events of 9/11. And they were carrying on a lot of corrupt practices within these proceedings. Not so that the families would get the money, but that they would keep as much of the money in the trust fund as possible and then walk away with whatever was left. The abuse that was carried out to many of these families is unconscionable. And he was directly involved in that, Rendon versus TSA. He was also involved in cases involving Iran and actually fixing market prices by affecting supply and demand by blocking parts from getting into Iran. And this is well before the war started. And this is, he's involved in this case, in my case, as is Alex Kaczynski, John Snow, former head CEO, president of CSX Rail and Shipping Company. The rail and or shipping companies are involved deeply in what is going on in taking down the United States Merchant Marine. And they are doing this not for corporate profit, not for profit for Wall Street. That is part of the reason, and that's why many of these people have been involved in or participating in or helping, but much of this is being driven from Europe and especially England to bring much of the maritime commerce and control back into England. And ABS is involved in this, the Coast Guard is involved in this. You can look to any other, Lloyd's of London, of course, but let me go ahead and read this order. This matter came to be heard on the Coast Guard's response, or quote-unquote request for status conference dated February 22nd, 2008 and March 24th, 2008. The Coast Guard asked for, and this, remember, this is the Coast Guard prosecuting me. It's a Coast Guard officer who's sitting in as judge. It's a Coast Guard officer in uniform who's acting as a JAG prosecutor. The Coast Guard asked for a telephonic status conference at the earliest opportunity due to the passage of time since the last filed activity. It's been 5 years and I still haven't had a hearing. They're supposed to bring charges, if I were actually in the Coast Guard. The Coast Guard is using its own internal administrative remedial system that's supposed to not take any life, liberty, or property away from an individual and use it only for their men and women in uniform of the Coast Guard and no one else. This is gross waste, fraud, abuse, and gross mismanagement. Under 33 CFR 20.501A, any party may motion request a conference. Subsection B prescribes that the ALJ is administrative law judge, in this case he's basically a military judge, may direct the parties to attend one or more conferences before or during a hearing. We've not had a hearing in 5 years and this has been going on. I've lost both my homes, my credit. I was actually homeless and on the street for a period of time. And you won't even believe the charges and what's going on in here. And it is to shut me up about blowing the whistle on many of these corruptions and the corrupt practices herein of these type proceedings in and of themselves, do so with an administrative bullet of sorts or carry on fratricide to where these individuals are literally trying to put me in an early grave. Subsection D prescribes that the ALJ shall give reasonable notice of the time and place of any conference to the parties and to interested persons if invited. The conference may occur in person, by telephone, or by other appropriate means. They try to do as much of this in absentia, off the record, and telephonically if they can, so there is no transcript, there is no recordation of the events. And what they also try to do is to carry on the proceedings with only a court reporter and no video, so that the judge can enter comments into the record that when you viewed them in a video, you'd be, why is he saying that? But in the transcripts, it comes off entirely different, and they know this, and they use that to try to inject some type of activity that may not even be going on in the courtroom. The judge accused me of acting up when I was sitting there defending myself, not going anywhere, just speaking up and objecting. And he tried to throw in some comments as if I was like rushing the bench, which is just completely ridiculous. Pursuant to the Coast Guard's February 22nd, 2008 request, Ms. Regina May of this office attempted to contact the parties by telephone on or about February 25th, 2008 to arrange for the teleconference to ascertain when it would be convenient for them to participate. And I've asked for in-person oral due process hearings to be recorded by video in all these proceedings, because the Coast Guard is not an agency that you can trust. And I know, and I'm telling you this from personal experience, they lie, they cheat, they've stolen medical records, falsified medical records. They even went as far as to put out a BOLO, a be on the lookout warning poster saying that I may be dangerous. This is your hard-earned tax dollars at work. This is what they did to Martin Luther King. This is what they did to Kennedy. This is what they've done to union activists. This is what they've done to political dissidents. And this is not coming from Wall Street. This is not coming from the bankers, unless you understand clearly who owns and controls them. And it is England, Italy, Spain, Austria, Bavaria, Germany, and a few other countries you could probably throw in there. Russia has a good play, and a lot of countries in the Middle East as well. The Coast Guard investigating officer advised, and they had the citing officer, the investigating officer, the policeman turn into and become the prosecutor. They let this guy Triboulet go away to law school for the last 4 or 5 years. Now he's come back in as a prosecutor, which is a violation of separation of powers and separation of duties, as they call it themselves. Miss May also called respondent's number. There was no answer, so she left a voicemail. And I contest everything that's in this, or majority of it. And that's one reason why they don't do it where it's transcribed, to where there's an actual recording of what's going on, especially audio visual, because then they can memorialize it themselves and make stuff up. When respondent called back later that day, Miss May was temporarily out of the office, so I picked up the phone. This is Judge Brzezinski speaking. And he hid the fact that he is a lieutenant commander in the Coast Guard when I confronted him on recusal as the ALJ if he had ever served on a ship or in the service. And he did not say that, yes, I'm a lieutenant commander in the Coast Guard. He hid that information. So only God knows what else he is hiding. Respondent was angry and agitated. And, if you put yourself in my shoes and what's going on, even for him to say that, I think it's almost a given. Anyone who is being prosecuted by a branch of military that they're not in might be just a little angry and agitated, especially if they know and understand the Constitution and where things are coming from. He told me that he had not received the Coast Guard's request for a status conference, and since I received it before he did, it was an ex-parte communication. Point of that, they're not supposed to be carrying on any kind of communication. It's supposed to be between the parties first and foremost. They're supposed to come to some kind of agreement. If they don't, then they contact and file some kind of a written notice with the court and to the opposing party as to what their intents are. The judge has been acting as prosecutor in these proceedings, has actually taken over prosecution himself in most regards. And you can actually review some of the transcripts. They're up online from the October 23rd, 2007 proceedings. And there's also ones from August 25th, 26th, 2003, because this has been going on for 5 years. Conference, and since I explained to him that a request for a status conference is not an ex-parte communication, and that since a great deal of time had elapsed due to securing the services of an appropriate examining psychiatrist, they're trying to force me under a mental health examination, a psychiatrist, all paid for by you, the federal taxpayer, through the Coast Guard, a branch of service that I've never been in. I believed a status conference was appropriate. He continued in a contumacious fashion, demanding that any conference be in person and not by telephone. I've asked this repeatedly. That's why I've been angry and a little bit agitated, because these guys are not trustworthy. I've tried to do everything in person with video recording equipment there, so there is a audio-visual history of what is going on, and they can't just make stuff up like they have a tendency to do. I explained to him that a request for a status conference is not ex-parte communication, and that since a great deal of time had elapsed due to securing the services of an appropriate examining psychiatrist, I believed a status conference was appropriate. And I've asked for a hearing in the last 5 years. Even in the October 23rd, 2007 proceeding, I asked that that be converted to a hearing, and they denied it. The Coast Guard said it wasn't ready, and it's been 5 years. He continued in a contumacious fashion, demanding that any conference be in person, not by telephone. He also demanded that the Coast Guard investigating officer, he's not an investigating officer, he's now a prosecutor, contact him personally first. Otherwise, it's an ex parte communication. I recall, and this is the Walter J. Brzezinski, the ALJ or military law judge speaking, I recall mentioning to respondent that very shortly I will be sending out an order for him to contact the psychiatrist that I chose per the Coast Guard regulations, and for him to make an appointment for an examination. Not being able to further communicate effectively with the respondent, and after arguing back and forth on his due process rights violation claims, I politely ended the conversation. So he's bringing up in here that I'm complaining about due process rights. He wanted me to go to a quote-unquote mental health examination before the due process hearing on the merits of the case, so that they would have, and he also wanted this quote-unquote examination to be held off the record. He actually ordered that. And you start to see that, there's something going on here, and it's not necessarily me. After a lengthy process ascertaining available and appropriate medical professionals in the Los Angeles, this is going on in your backyard, your neighborhood, Long Beach area, and following government procurement procedures for their services, which I brought up that they're not, because they're not supposed to be procuring psychiatric services for civilians that are not in their branch of service. I've been bringing this up as a violation of federal contracting issues, and I know because I've been trained on that as not only a port engineer, but a federal contracting officer. I've worked for GE, I've worked for the Navy at Pearl, I've been a civil service employee down as a port engineer down in San Diego at the sub base and more. I know federal contracting. I know what these guys are doing is not only stealing from the American taxpayers to carry on this type of behavior over the last 5 years in a false flag prosecution using the military to prosecute a civilian, but to create bad precedents to use it upon you. If this continues and they continue with what they're doing and they're successful, they will be able to grab you off the street and force you as a civilian under a psychiatric examination. I issued an order directing psychiatric examination on February 26, 2008. In that order, respondent was directed to contact Dr. Joseph Simpson, MD, PhD. He's here in Long Beach, and I give the good doctor 2 thumbs up to an extent because he did recuse himself. By March 28, 2008, and make arrangements for a mental status examination. The only mental status examination the Coast Guard has the right to impose upon me is a professional engineering license examination. And instead, because of the whistleblowing activities, they're trying to make it another issue and violate due process like you wouldn't believe and carry on literally torture. And that's why they're trying to redefine torture and playing all these games with Guantanamo, Abu Ghraib, our system of due process and more, Military Commissions Act. They're preparing us just like they prepared the German people before they were launched into a world war. And these guys are doing the same thing here in the United States to us. And it's one reason why they want to shut us up, or shut me up, is because I stand strongly against the Iraq war, because I know what it's about. It's about corrupt practices like this guy Brzezinski's involved in fixing oil prices and more. But it's also about war profiteering, oil profiteering. They just put an Admiral Brewer, in charge of LA Unified School District as the superintendent. And the reason they did that was to put an admiral in charge as superintendent of LA Unified School District, the second largest school district in the nation, to turn it into a nursery for soldiers and sailors to be used for World War, and not just war in Afghanistan and Iraq. These guys are crazy, and they must be confronted, and they must be stopped. They may take me out, they may take me down. I've been fighting this for 5 years, and I'm trying to get out as much information to you, the American people, the public, about what is going on in our country, so that you can focus your efforts on who is doing it and why. And there is an extremely foreign flavor to everything that is going on, and much of it is being routed through England, from Austria, Bavaria, Germany, and throwing Italy and Spain in there as well. That's why novels like Kafka's The Trial are starting to become very, timely or timeless. After a lengthy process, I'm going back over this, ascertaining available and appropriate medical professionals in the Los Angeles, Long Beach area, and following government procurement procedures for their services. He's thrown that in, saying that he's compliant, which he hasn't been, and because I've called him on it. I issued an order directing psychiatric examination on February 26, 2008. In that order, respondent was directed to contact Dr. Joseph Simpson, MD, PhD, by March 28, 2008, and make arrangements for a mental status examination. The order also provided that Dr. Simpson send me his written report by August 9, 2008. On or about February 27, 2008, respondent called to this office, and I happened to answer the phone. Realizing it was respondent making more demands as a result of the order I issued on February 26, 2008, I turned it over to Ms. May. And I disagree with this, but this is why all of this should be recorded and done on the record in a room with all the people there with audio-visual equipment. I turned it over to Ms. May, whereupon respondent demanded to know Dr. Simpson's credentials. He demanded to know the regulation that support the mental health evaluation, and also questioned why the Coast Guard did not contact him prior to sending out its request for status conference. Again, he accused the Coast Guard of having ex parte communication with the ALJ office. As he demanded of me, he also demanded a quote-unquote in-person hearing of Ms. May. Respondent was agitated and angry throughout the telephone call. I've been asking all along for in-person oral due process hearings over the last 5 years. We even had the proceedings on August 23rd or 26, 27, 2003 that could have been converted and had a hearing then and there. That was 4 or 5 years ago. And then also most recently on October 23rd, 2007, where I asked at least 4 or 5 times that it be converted into a hearing, and they refused it, because even the motion for recusal of the ALJ, which I requested, is supposed to occur from within the hearing, and they won't allow me into a hearing, and you can wonder why. Ms. May responded to 33 CFR 20.1313, which was also cited in my order of October 26, 2007, my order of February 26, 2008, as authority to direct respondent to submit to a psychiatric examination. They're using rules to overrun law and even the Constitution and amendments. Further, Ms. May told respondent that he needed to contact the Coast Guard directly to find out why they did not contact him prior to submitting the request for status conference. Lastly, Ms. May advised, and this goes into the whole issue of good Germans, because these people are knowingly, willingly complying and assisting in the torture of another human being. And I'm telling you, I've lived through this for the last 5 years, and it is torture. I would not want anyone else to go through what I've been through in the last 5 years. And that's why I'm fighting it and fighting tooth and nail to stay alive, to tell people, to warn people, to get as much information out and recorded for posterity, so that people looking at this will hopefully go back and prosecute these people for war crimes. Ms. May advised respondent that she was not about to argue with him and that he will have to address his issues in writing. Respondent hung up, but immediately called back to the state that he was going to go on a radio talk show, and they're putting this in there, and I'm going out and telling everyone and anyone I have a show right after this at 5:30, and I will go on the air again to let people know what's going on, to let everyone know how our office does things and how this due process rights are violated and how he's treated unfairly by the judge. And the Coast Guard respondent then hung up. Was separate, sorry, and by the judge and the Coast Guard, period. Respondent then hung up. I'm not in the Coast Guard, never been in the Coast Guard. Within the next few days, Dr. Simpson advised via fax that he was withdrawn from the case. The doctor recused himself. I told him what was going on. He did the right thing and he recused himself. After he withdrew, action was taken immediately to secure the services of another psychiatrist. While the procurement process to secure the services of another examining psychiatrist pursuant to 33 CFR 20.1313 has proved to be a lengthy, they're having problems with it because they haven't been following it. They're making it up as they go along. They don't have a program to do this because the Coast Guard is not supposed to be contracting out as a department or agency, whether it's Homeland Security or not, to use military assets to prosecute, let alone force civilians into mental health examinations. A significant amount of time has elapsed since the remand. This case was remanded. Brodzinski is not the first judge. I've been through 2 judges on this now. ALJ McKenna was the first. This case was, he ruled on it, summary decision, denied me a hearing. I had to appeal, and even though he declared me to be medically, mentally incompetent, I won the decision, the appeal. They sent it back for a hearing. It's now been 1.5 years since it was remanded. Brodzinski took it over. As soon as it was remanded, ALJ McKenna recused himself for unknown reasons, not a matter of record. I would have to say for corruption. And Brzezinski has taken it over. In the last year and a half, we still haven't had a hearing, and this has been going on for 5 or 6 years. And many of the charges date back to not only 1995, 98, 2000, and 2000, 2001, 2002, and throughout all these proceedings, they say that I am and continue to be acting under the authority of my federal license, federal position, federal authority, in and throughout these proceedings, except I'm being denied pay, medical benefits, legal aid, and more. And that's why I'm coming out to warn you, tell you about some of the things that are going on. Let me finish this real quick. Therefore, a hearing will be held as soon as practicable, and an order for another psychiatric examination will be issued as soon as the procurement request has been approved. Your tax dollars hard at work. This is like the Coast Guard coming out and saying to Keith Olbermann, we're coming after you and we want you to undergo a mental health examination, Keith. Not that I'm in any keeping or good company with Keith Olbermann other than my protest of what's going on, along with many others here in the United States. But, we'll leave that as it is. The record shows that the Coast Guard submitted its updated exhibit and witness list on November 9th, 2007. The respondent submitted his exhibit and witness list, this was done by counsel when I had counsel at the time, on July 7th, and his updated list on July 25th of 2003. Wherefore, order. It is hereby ordered that the hearing in this matter will be held commencing May 20th, 2008, supposedly, I don't think it'll happen, at the Glenn Anderson Federal Building, 501 West Ocean Boulevard, room 5150, Long Beach, California. Please come. It is further ordered that since the parties have previously submitted their exhibit and witness list prior to the remand, they may supplement or resubmit same by May 1st, 2008. It is further ordered the motions for telephonic testimony may be submitted by May 1st, 2008. It is further ordered that another order directing psychiatric examination will be forthcoming as soon as the procurement process is completed. And this was signed April 11th, 2008 in New York by Walter J. Brzezinski. And we're here in California. Peace, people. More truth coming at you. Talk to you soon.